Welcome back to our corporates. Delay in filing of PIS 3 56 days resulted into a penalty of a huge amount, 1,16,000 per day, 1,000 rupees. Now we will see the very recent ROC adjudication order dated 25th September 2025. So, brief context. Today we are discussing an important adjudication order issued by ROC Delhi on 25th September 2025. Here the company, the Game Changers Texfab Limited, and its directors penalized for delay in filing of Return of Allotment, that is E-Form PAS3, under Section 42, Subsection 8 of the Companies Act 2013. So now we are going to discuss overall legal framework of private placement, provisions under Section 42(8), 42(9), and 454, and certain exemptions for 446(b) for like small companies, startups. And we also discuss the facts of the case and what is the ROC reasoning before the imposing penalty, and what exactly the penalties imposed on the directors and on the company, and the practical lessons for the companies and directors. This is what we are going to discuss. First of all, I will explain you the legal framework for private placement. Section 42 talks about the private placement. It governs the issue of securities by a company through private placement. And Section 42, subsection 8, this is what a company shall file with the ROC a return of allotment, that is E-Form PAS3, in such manner as may be prescribed. This is what section says, including complete list of allottees within 15 days from the date of allotment of securities. Within 15 days from the date of allotment of securities, E-Form PAS3 has to be filed. E-Form PAS3 is prescribed for the purpose for filing of return of allotment. The timelines are, example will take, suppose the allotment date is 0, then within 15 days PAS3 must be filed. Example, the date of allotment is 10th July 2025. So the due date is, PAS3 due date is 15 days, it means 25th July 2025, the company has to file. So we'll go to the penalty. Section 42, subsection 9 provides a stringent penalty for failure. A company see 1,000 per day of default, and promoters or directors 1,000 per day. So they can go up to 25 lakh form filing delay, which causes to 25 lakh. This is the maximum cap. Not only this, we'll talk about other relevant provisions. Section 454, adjudication of penalties. It empowers, Section 454 empowers ROC as an adjudication officer to levy penalties. Appeals lie with the RD, Regional Director. Penalties are payable through MCA e-adjudication facility. And we also talk about the lesser penalties for certain companies under Section 446(b). Small companies, OPCs, startups, they enjoy reduced penalties. But subsidiary companies are excluded in that shield. Then what is small company? Section 2, subsection 85. A company that is not a public company, a holding or subsidiary company, and or Section 8 company, or a company governed by special acts. These are all not small companies. And what is subsidiary company? Section 2, subsection 87. Company in which another company controls more than 50% of the share capital or board composition. So that is subsidiary company. Here is the important, that is why I am telling you the definitions. When we are going through the facts of the company, these definitions are important to understand. See the background of the company. This company name is a Game Changers Texfab Limited. Registered office is Delhi. And the shares are allotted on 1st May 2015. Actually, it is allotted on 1st May 2015. Board resolved to issue 15,000 equity shares under Section 42. And 27th May 2015 is a special resolution passed by the shareholders. Then after that, next day, 28th May 2015 to 26th June 2015, offer period. So next day offer period open. The period is given up to 27th June 2015. So 1 month time they have given. PS4 circulated. 27th May 2015 to 27th June 2015 offer period the company has given. And 10th July 2015 shares allotted via board resolution. Then deadline is 25th July 2015 because within 15 days form has to be filed. Up to this okay. But company filed a form on 19th September 2015. So the delayed by 56 days. So what happened after that application for adjudication? Suo motu filed via GNL1. This is filed on 2024, October 5th. Company admitted default and pleaded it was unintentional. Company pleaded it was unintentional. So arguments raised by the company is claim for small company benefit because Section 446B gives some exemption. So this is what claimed by the company. Company argued it was a small company at the time of default and ROC rejected since 99.9% shares were held by Force Multiplier E-Commerce Private Limited. So the company was subsidiary, hence not eligible, not a small company. This is a subsidiary company. So designation officer in default. So OID, officer in default. Company passed a board resolution on 1st August 2015 designating Ankur Agrawal as a officer in default. So requested penalty may be imposed only on him. ROC observed default began on 26th July 2015. So other directors also liable for the past first 6 days. Lack of professional guidance. So company claimed default happened due to absence of professional advice. ROC said ignorance of law is no excuse. And we will see the reasoning, ROC's reasoning in this case, because the delay is 56 days and Section 42(8) clearly violated. Section 42 subsection 9 penalty mandatory. Company cannot claim small company benefit because it is a subsidiary. Officer in default after the default commence does not absolve earlier directors. So the penalty imposed is per day 1,000 rupees. Company 56 days, 56,000. Directors, so the 6 days were there, 2 directors, 6,000 each. 1 director was there, is officer in default, 48 days. So the penalty total 1,60,000. And also directed to pay via e-adjudication facility within 90 days. Directors has to pay from personal income, not from company. Company must disclose the penalty in the next board report. They have a right to appeal before RD within 60 days. Here the practical lessons for companies. Strict timelines, particularly for PAS3, must be filed within 15 days. No relaxation. No excuse of lack of guidance. Directors must ensure compliance even without professional help. They cannot excuse that lack of guidance. And subsidiary companies cannot claim benefit of reduced penalty under Section 446B. Officer in default, designation works only prospectively. They cannot avoid liability for earlier periods. And board report disclosure is mandatory. Every adjudication order must be disclosed in the board report to ensure transparency. Appeal right is there 60 days before RD. So the conclusion is this case highlights the importance timely filing under Companies Act 2013. 56 days delay resulted in 1.16 lakh penalty. Directors must exercise due diligence, maintain corporate governance, and ensure timely compliance. Ignorance of law is not defense. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of our latest videos. Thank you.